Court of Appeals, Division 1 is now in session.
Please be seated.
Where's everybody?
We're on the record in case CV1475, Origami et al. Versus Connolly. Counsel, this is the time set for oral argument. These proceedings are being audio and video recorded. A link to the court's website will be available in a few days, so be aware of that. Please identify yourself and your client during oral argument. Each side has 20 minutes. Keep track of your time on the podium in front of you. There's a clock. And counsel for appellant, you certainly can set aside some time for rebuttal. Keep in mind, we have read everything. We've read the briefs. We've talked about the case. So we're very familiar with the issues in the case. Is it, counsel, how do you pronounce your name?
David Ball.
Oh, David Ball. Okay. Mr. Ball, you may proceed. I was looking at the other name, so, no.
Hopefully my name was one of the easier names to pronounce.
What's the name of your co-counsel?
Jamie Palfi.
Okay, that's what I was saying was hard to pronounce, but these two up here are giving me a hard time. All right, counsel, you may proceed.
Good morning, Your Honors.
You can direct your argument towards me and forget the other two here.
Okay, you've got it. If it pleases the court, my name is David Ball. I represent the defendant appellant Tom Connolly, who is a lawyer here in Phoenix area. This is an important case for Mr. Connolly, for the legal profession in general, because of the lack of the dearth, if you will, the lack of case law here in Arizona interpreting the application or the interplay between Rules 1.9 and Rules 118, 118. I'll call them 1.9 and 118. I think it's 1.9 and 1.18. But with respect to the disqualification of counsel under certain circumstances. And in deciding these issues, we have to first start with the public policy, which is a policy in favor of allowing clients or prospective clients the right to choose counsel of choice. And the courts balance that interest, that public policy interest, with the need to protect former clients or prospective clients in the event they've had communications or a relationship with the counsel being retained by the new party. And the courts, not the courts, but, well, the courts in jurisdictions that have addressed this, but the rules are set up to recognize a distinction between situations involving a former client, on the one hand, which Rule 1.9 applies, or a prospective client on the other, in which case Rule 118 applies. And the rules, the comments to the rules, and the courts that have addressed those rules in other jurisdictions have recognized that prospective clients under Rule 118 are not entitled to the same or equivalent protection as former clients. And thus there's a higher or more rigid standard in determining, or that must be met, before a lawyer will be disqualified.
Now, counsel, before you proceed, it's my understanding that your client's complaining that he was prohibited from representing Christopher Ellis.
Yes, Your Honor.
And Mr. Ellis had claims against Origami Owl.
Yes, Your Honor.
But Mr. Ellis no longer has claims against Origami Owl, is that right?
After Mr. Connolly was disqualified, apparently those claims between Mr. Ellis and Origami Owl were resolved.
We can't give him back his business from that.
Well, you can't give him back the business, but I think Mr. Connolly, and one of the reasons this appeal is still ripe for decision and is not moot, is because of two reasons. Number one, as a result of the injunction issued prohibiting Mr. Connolly from representing Mr. Ellis, Mr. Connolly suffered damage. Number two, there is still pending a breach of fiduciary duty claim brought by Origami Owl against Mr. Connolly, for which they seek damages. And so this is still an important issue because the order of injunction could have collateral estoppel effect or could be considered law of the case with respect to the still pending claim for breach of fiduciary duty. And thirdly,
Would that be so if we determined it to be moot?
Well, again, Your Honor, I don't think, yes, because there is still an order issued by the trial court that Mr. Connolly was enjoined from representing Mr. Ellis in connection with that dispute. And Origami Al is seeking damages as a result of that alleged breach of fiduciary duty. And then lastly, Mr. Connolly would be entitled, or could be entitled, to damages under Arizona statutory law for a party who was wrongfully enjoined. So the appeal is still very much alive and has still very much impact upon the future proceedings of this case. We've presented 3 issues on appeal outlined in our brief. I'm going to focus, unless the court has questions on the other 2, I'm going to focus on what I think, or what we think, is the most important and most significant issue, and that is that the trial court abused its discretion by enjoining Mr. Connolly from representing Ellis based upon its misapplication of Rule 118, and that misapplication constituted an abuse of discretion. Now, the plaintiffs, Origami Al, the appellants, filed the instant action against Connolly, seeking to enjoin him from representing Ellis in the connection with a contract dispute with Origami, based upon Rule 1.9, claiming that Origami Al and Mr. Connolly had a prior attorney-client relationship. We responded by saying, no, 1.9 is not applicable. There was no prior attorney-client relationship between Connolly and Origami Al, and instead 118 applies. Now, 118 requires 2 elements to be satisfied before a court can properly enjoin an attorney from that situation. Number 1, the 2 legal matters must be the same or substantially related. And that "and" is important because it's conjunctive. And the information received by the attorney from the prior prospective client could be significantly harmful to the prior prospective client in the subsequent matter. So they have to show first a substantially related, that the 2 matters are substantially related, and secondly, that significant harm could result. Both prongs. Now, if we look at the trial court's decision, the court initially started off perfectly right. The court disagreed with Origami Al, agreed with Connolly that no, 1.9 doesn't apply. There was no attorney-client relationship between the parties. No prior attorney-client relationship. And instead, 1.18 was applicable. However, having made that proper determination, then the court went off track and misapplied the law and determined that Mr. Connolly should be enjoined from representing Mr. Ellis in connection with that contract dispute. So if we look at 1.18 and the construction of 1.18, we have to first start with the fact that there is no Arizona appellate decisions, no Arizona appellate cases construing Rule 118. However, we can get guidance from 2 sources. Number 1, we can get guidance from the comments to the rule. And number 2, we can get guidance from courts from other jurisdictions that have construed the model Rule 118. Now, the Arizona Rule 118 is fashioned after the model Rule 118. They're identical in all major respects. So if we look at comment 1 to Rule 118, we first see that recognizing the strong public policy of allowing clients to choose counsel of their choice, 118 entitles prospective clients, like Origami Al, some, but not all of the same protections afforded to a prior client under Rule 1.9. Comment 3 contemplates that having an initial consultation with a prospective client, that the prospective client may reveal some information to their potential lawyer, and that information must not then thereafter be used to the prospective client's or adversely or contrary to the prospective client's interests. So comment 3 contemplates that information is exchanged and that information could not later be used or should not later be used. And then comment number 7 to 118 provides that an attorney is not prohibited from representing a client whose interests are adverse to those of the prospective client in the same or substantially related matter unless the attorney has received from the prospective client information that could be significantly harmful if used against the prospective client. Thus, again, a two-prong test. The lower court actually misapplied both prongs. With regard to the substantial relationship prong, the court misapplied that test. The court did recognize that Ellis's dispute, Ellis was the former, or the client that Mr. Connolly was going to represent, the former employee of Origami Al, that Ellis's dispute with Origami Al was based in contract, and it concerned the validity and enforceability of certain terms and provisions contained in that contract between Ellis and Origami Al. However, the court did not compare that contract dispute with any matter upon which Connolly previously discussed with Origami Al. Now, the evidence in the trial court, and this is not a question of giving deference to findings of fact, but the evidence in the trial court dealt with the prior discussions between Connolly and Origami Al dealt with the operating agreement, not the contract.
Well, but didn't the member of Origami Al, Chris Weems, tell Mr. Connolly about how she had reserved Ellis's interest through her own LLC as she was looking for some advice as to how to structure the operating agreement for the OWL to protect her daughter's interest?
Certainly. There was some testimony to that effect, but it was clear that there was no testimony with respect to the source, or there was no testimony as to the source of Mr. Ellis's claim for the 5% interest. There was no discussion between Mr. Connolly and Origami Al representatives with regard to the contract itself. The substantial relationship test requires a showing that the prior work or discussions between the parties and the current dispute involve the same or substantially similar subject matter. Now, the same or substantially similar, that language, again, is not defined in Rule 118, but the same requirement is present in Rule 19. So we can look to the comments of Rule 19 to see what does substantially same mean. Substantially related if they involve the same transaction or dispute, or if substantial risks that confidential information obtained in the prior relationship would materially advance the client's interest in the next. That's comment 3. And if you look at the Ampanaro case, which we've cited, the purpose of the rule is not to be used as a sword, but the burden is upon the prior client under Rule 19 or the prospective client under Rule 118, like Origami Al, to show significant reason to disqualify. Now, the trial court initially determined, if we look at the court's opinion, actually initially properly applied the test, the substantial relationship test, and compared the communications with Connolly about the operating agreement and other matters to the Ellis contract dispute, and found that there was no substantial relationship, that no substantial relationship existed. In fact, if we look at the opinion, it reads, plaintiffs contend that Mr. Ellis's claim against Origami Al is substantially related to the company's operating agreement. The evidence does not support this claim. Ellis's claim against Origami arises from the alleged breach of a written employment contract and representations made to him, not the operating agreement. So, having made that determination, the court should have determined that no substantial relationship existed. But more importantly,
you seem to presume that when Ms. Weems was talking to Mr. Connolly, she was doing so as Origami Owl, and at least as I understood the testimony from the trial, she was trying to protect her own interest in Origami Owl and those of her daughter. So she wasn't, and Origami had their own counsel trying to draft the agreement. But she was trying to get information to structure it. And so it doesn't seem that Origami Owl had come to Mr. Connolly so much as Ms. Weems to protect her interest in the entity.
It may be true, Your Honor, but the parties to this case where Origami Owl brought the claim against Mr. Connolly, seeking to enjoin him from representing Origami Owl. And the court then noted there was scant information presented in the lower court proceeding regarding Mr. Ellis's dispute. There was no evidence that the suit was filed. If it's been filed, the complaint was not in evidence, etc. But I want to move on, unless the court has other questions, because the most important deficiency in the court's determination was its failure to require the second prong of the test to be met, the substantial harm. And in fact, what the court ultimately decided is that they made the assumption, the presumption, having found that a substantial relationship existed, the court must determine that substantial harm could result if used. The comments to the Rule 1.8 clearly provide that the party seeking the injunctive relief, seeking the disqualification, must introduce evidence to satisfy both prongs of the test. Both prongs, the substantial relationship and the substantial harm. And to presume that substantial harm could result as a result of a finding, although we contend that that finding was inappropriate, but as a result of a finding that a substantial relationship existed, in essence does away with that second test.
I'm sorry, counsel, so your contention is there's no evidence that there was any relationship between the conversations that Weems had with Connolly and the subsequent lawsuit with Ellis?
There's no evidence of how the conversations with Mr. Connolly related to the contract dispute between Ellis and Origami.
Well, now, Origami fired Ellis.
Yes.
So that lawsuit surrounds the employment contract that he had?
Well, Origami fired Ellis subsequent to the initial consultation between Connolly and Origami Owl.
Right, but isn't it alleged that Weems talked to Connolly about Ellis's agreement during their consultation?
There was discussion, there was evidence that Weems talked about the relationship between Origami Owl and Ellis and whether or not he had an ownership interest and how to take certain steps with respect to that ownership interest.
How on earth can that not be related? He's going to file a lawsuit based upon his relationship with the company, and one of the principals in the company talked to the same lawyer about his relationship with the company.
Because
that's not a substantial relationship, or there's not a potential for a conflict?
there was not any evidence, Your Honor, presented at the trial court as to how those discussions, those initial discussions, related to the contract dispute between Ellis and Origami Owl. And that's our position with respect to substantially related. But even if the court determines that there was a substantial relationship between the prior consultation and the current retention or potential retention, Rule 118 requires a second prong to be satisfied, that there has to be a clear, compelling showing of evidence that the prior discussions between Origami Owl and Connolly could result in substantial harm to Origami Owl in connection with the dispute with Ellis. And the court, in essence, assumed that because they were substantially related, or because the court determined they were substantially related, that they would presume that there would be significant harm. And that is a misapplication of law. And in fact, Your Honor, there was no evidence whatsoever presented by Origami Al with regard to the specifics of any substantial harm. And there's a reason why they didn't do that. It's because Origami Al was proceeding in the trial court under Rule 19. 19 allows that presumption. There was no need under Rule 19 to present that evidence of substantial harm. But 118 does not afford prospective clients that same presumption and that same extent of protection. And Rule 118 does require a specific showing of the significant harm. And we can find that in the various case law. There's a New Jersey Supreme Court case that we've cited in our brief that deals with Model Rule 118 and recognizes that the presumption against the disqualifying lawyer, except when it recognizes that disqualifying counsel, except when absolutely necessary, has to depend upon a clear showing of the specifics of the harm, substantial harm that could result. Now, I was going to reserve 5 minutes, I didn't, but the three arguments proposed by the appellee with regard to that issue are all unavailing. It's not a question of whether or not the court made proper findings of fact. This is an issue of misapplication of law. The second argument that they present is that they were not required to reveal specifics.
I think, Counsel, I think you've stated that.
Okay.
Thank you.
Okay. Thank you, Your Honor.
Counsel?
Good morning, Your Honors. I'm Scott F. Gibson on behalf of the appellees Origami Al and Ninox Enterprises. In an answer to your question, Ninox is the entity that holds the interest that Chrissy and Bella hold. This case is fundamentally about what it means to be a lawyer. Being a lawyer is different than any other occupation. We don't get to pick and choose. We don't get to, we have to look out for the interests of our clients even when it's in our own personal, not in our best interest. We have a solemn duty to protect our clients. We have a solemn duty to protect the information that our clients and prospective clients share with us. And that is precisely about what this case is about. When you get into an issue about disqualification, as we have in this case, it's not about what's best for the lawyer. It's not about what the lawyer's interest is. It's what's about the best interest of the client. That's what we addressed here. And that's why the courts hold that when you're in a disqualification situation, you favor disqualification in a close situation.
Counsel, if we were to determine this appeal is moot, is it your position that the trial court's rulings are somehow law of the case and or res judicata for other proceedings?
It would be at least as to his disqualification, Your Honor, but as to the issues regarding his breach of fiduciary duty, those issues are still open. We've not taken any evidence regarding that.
Right, but if he gets the damages award against him because he was disqualified
It wouldn't be
supposedly properly, and you're going to say he can't litigate that anymore?
It wouldn't be because he was disqualified. It was because he breached fiduciary duties. And I do believe that is a different standard. We have not even begun to address those issues. They've all been put on hold while we're here at the Court of Appeals. But Mr. Connolly, and in similar vein, Your Honor, Mr. Connolly doesn't have standing to contest this case because he's not personally aggrieved. If anyone is aggrieved in this matter by the issuance
He
of
seems to say he's aggrieved because he's facing a damages award.
that's not been decided. That is something that no rulings have been taken, no evidence has been taken. The issue is completely out there. It's only a claim that is pending right now.
Ruling that is being challenged here, that he needed to be disqualified, in no way subjects him to liability.
I don't believe it does, Your Honor. we would then have to address the issues of whether he breached fiduciary duties, separate and apart from that issue. His lack of standing, though, disqualifies him from pursuing this claim because he's not personally aggrieved. If anyone is, it's Mr. Ellis.
I guess he's also contending, though, that he would have represented Mr. Ellis, and this lawsuit and this action interfered with that, so he lost the ability but to make some fees and to have that attorney-client relationship.
That's where being a lawyer is different from every other business, Your Honor. You have to look out for the interest of your clients. You have to look out for the interest of your prospective clients.
I know, and that's not really what I was saying. I'm just sort of pointing out what I think his position might be in terms of how he was aggrieved. Whether that's right or wrong, I mean, I get that.
And again, that's never a consideration in a disqualification case. This case was filed as a complaint against Mr. Connolly rather than a proceeding in an underlying matter because Mr. Ellis had not yet filed suit. We had asked Mr. Connolly to withdraw voluntarily, and he would not. And so rather than wait to be sued and then move to disqualify him, we did this initially up front. Let's talk a little about disqualification. Judge Gould, you're right. There is a substantial relationship.
I'm sorry, say that again?
You're right. There is a substantial relationship.
It's going to be tough to live with.
I know. I love it when my kids tell me I'm right, and probably occurs about as often as judges get told you're right. When Chrissy Weems went and talked with Mr. Connolly a year before this litigation arose and talked to him in detail about Chris Ellis and his ownership interest, that is related to Mr. Ellis's claim for litigation based on his ownership interest. There's abundant evidence that occurred. We have Chrissy's testimony. We have Mike Farron's testimony. We have documents and evidence. We have the findings of the court. There's a substantial relationship here. And so the question becomes, is there harm? Now the rule, ER 1.18, addresses, excuse me just a moment, it says that an attorney may not or shall not use or reveal information, use or reveal, those are the 2 points, and he's prohibited from taking on representation in a substantially related matter when the attorney received information, which we have here, and it could be significantly harmful. It could be significantly harmful. Not that we must prove the elements for which Mr. Connolly is going to use this evidence, not that we have to show how in great detail this is going to happen, but if we have conversations about Mr. Connolly's ownership interest, could that be used against, could that be harmful? Yes. I'm sorry, yes, Mr. Ellis's ownership interest. Could that be used against Origami Al in the proceedings? And the answer to that is unequivocally yes. What is the harm? This is where we get back to what it means to be a lawyer. The harm is the harm that comes to the system when client confidences are invaded, client confidences are compromised, client confidences are abused for personal gain. It's the harm to the prospective client, to every client that wants to share things in confidence with his lawyer and yet is not allowed to. It's the harm to every lawyer who vigorously protects client confidences, only to have someone compromise it because he can find a better engagement in which to occur. Judge Cooper specifically found the information they discussed, quote, could be significantly harmful if used, since Ellis and Origami are adverse to each other and the dispute concerns his interest in the company. Of course it could be harmful to take information about things that we discussed and use that in the case. That's why the rules of or the case law interpreting disqualification says when you have a case involving disqualification, you err on the side of disqualification because attorneys owe that duty to their clients. The attorney's interests are suppressed to the interest of the client, or in this case, the prospective client. Let's talk about one issue that Mr. Connolly didn't raise, the injunction bond. We've detailed that in our briefing. The rule requires an injunction bond for a TRO or a preliminary injunction, does not require it for a consolidated case consolidated on the merits where there's a trial that's held and where the trial court determines that that violation has occurred. There's no basis for the bond, and we've detailed that at great length. I ask you to affirm the decision of the trial court. Alternatively, we think rule that Mr. Connolly has no standing to pursue the claim, that the case is moot because of that fact. Thank you.
You're saying it's moot because he doesn't have any standing, or moot because he was enjoined and Ellis has since settled his claim?
Actually, it's moot for both reasons. Thank you.
All right, thank you, counsel. We'll take this matter under advisement and issue a written decision in due course. The court's in recess.